You go by.
Senator Franken,
Yeah.
you're next.
Thank you, Mr. Chairman, for holding today's hearing on this critical issue, and I want to thank my colleague from Ohio for introducing the Employer Misclassification Prevention Act, and which I'm proud to co-sponsor. And I think today's hearing is very good, and we're hearing good stuff from Senator Isaacson and from Senator Enzi that I'm sure can be addressed very easily, or can be addressed. And I want to say to Senator Enzi, I've been an employer, and because I know that was asked of Mr. Harris. I've been an employer. I've been an independent contractor. I have employed independent contractors. I've employed employees. Sometimes it's a little tricky, sometimes errors are made, but it's not that hard to know who's an independent contractor and who's an employee. And I actually believe that Senator Isaacson, who had a bigger company than I had, actually, I think my mom was an independent contractor for you, because she worked for Burnett in Minnesota. So I kind of understand this, Senator Enzi. I've been in this shoes. And I want to reward the businessmen who are doing this right. And I don't want to lose. I'm like Senator Isaacson. I want there to be withholding taxes that are held. And I want unemployment insurance paid. And I want to punish businesses that don't play by the rules. No one is categorically demonizing independent businesses that hire independent contractors. I didn't hear anybody doing that. But I got to tell you, when I go back to Minnesota, one of the biggest complaints I hear from my friends in the construction industry, not the real estate industry, not the entertainment industry, but in the construction industry, is that there are good laws on the books, but that there are dishonest players who keep finding loopholes, and they're the ones that are disadvantaging people who do play by the rules. And that's what we're trying to do here. Now, I have a rather technical question, Mr. Harris, specific to a situation that has arisen in Minnesota. A couple years ago, Minnesota implemented a law to tackle the misclassification problem. It basically required that independent contractors receive a certification from the State Department of Labor and Industry if individuals submitted documentation showing that they were legitimate contractors. And this seemed like a logical solution to the problem. However, unscrupulous employers have found a way around this. They've told workers to go register as a limited liability company. It's actually a very simple form to do this. It certifies that if certified as an LLC, the workers can keep working for the employer, but it would be considered a business-to-business transaction, and the employer could continue to avoid paying taxes, and the worker would not be protected by any labor laws. And this happens frequently to vulnerable workers, seasonal workers, those with less education, those with no other employment option. If federal wage and hour inspectors were to show up to a construction site and interview workers who revealed that they were told where and when to show up and what to do, but were technically LLCs, what would wage and hour be able to do in this situation? And would they be able to do anything more if Senator Brown's provisions were implemented into law?
The technical status of the worker as an LLC is not relevant to the test under the Fair Labor Standards Act, the economic realities test. It's only if the individual's actually operating as an arm's length business that they would be an independent contractor, at least out from under the definition of employee. But if our investigator were to show up and find that someone had been misclassified, there would be no consequence for the employer in the first instance, because under the law right now, it's not a violation to misclassify a worker, and that's one of the things that the Employee Misclassification Prevention Act would change. Second, if the employer had not kept the requisite records because the LLC actually was an employee, there's no penalty for failing to have kept the records under existing law. Our investigator couldn't issue any kind of a citation for civil money penalties. Under the EMPA, there would be civil money penalties available for record-keeping violations. What's intriguing about what's happening, what you're describing in Minnesota, is that the Minnesota state law has in it a couple of the provisions that are included in EMPA, the penalty for the establishment of a violation for misclassification, the existence of a presumption if there's no record keeping that someone is an employee. And I think what you're describing is showing that there's so much economic pressure on employers to get this competitive advantage particularly in construction, where it's a very competitive business, that they're trying to find new ways of getting out from under the law. So it shows that even if we succeed with our regulation or with the EMPA or both, we have to continue to be vigilant. We have to have an enforcement strategy. We have to have cooperation with the states. We have to not let form overtake substance. The LLC form is not the answer. The relationship is the answer. So I think that the problem that you're describing is solvable. It's not solvable with a single tool. I think we have to all work together to find several tools to go after it.
Thank you, and my time has expired.